Welcome back. The uMkhonto Wesizwe Party has approached the Constitutional Court challenging President Cyril Ramaphosa's decision to place Police Minister Senzo Mchunu on special leave instead of firing him. The party wants the Apex Court to set aside the appointment of Professor Firoz Cachalia as acting police minister. Now, joining us is Dr. Thanti, who's the chairperson of the Economic Transformation Committee of the National High Command in the MK Party, and legal expert Kevin Smith. Gentlemen, a very good evening to both of you, and thank you so much for joining us.
Thanks for having us.
Thank you.
All right, I think, Doc, maybe perhaps let's start with you. So the MK Party is approaching the Court for the reversal of the decisions that have been made by President Cyril Ramaphosa. Perhaps maybe let's just begin with you outlining, I think there are three main decisions. It's putting the minister on special leave. It's the appointment of Professor Firoz Cachalia, specifically under Section 91, subsection 3 of the Constitution, as well as the establishment of the commission. So maybe just unpack for us what your aim is as a party with this decision.
With the court challenge, yes, specifically? No, it's to reverse some of those decisions because to us, they appear very much to be unconstitutional and, quite frankly, very, very odd, right? Number one, I think it's fairly clear that the president has the power to appoint an acting minister, right? To appoint an acting minister. But Section 98 of the Constitution is very clear that minister needs to come from the existing cabinet. This minister, or this purported acting minister, is not a member of cabinet. So how that appointment is done, it's quite odd. The Constitution does give the president power to appoint a minister or two ministers outside of the National Assembly. It does give them that power. But to act, you have to be an existing cabinet member. But importantly, I think as well, we challenge the appointment of the Commission of Inquiry, right? To us, a judicial commission of inquiry, when the commissioner of KZN, the commissioner of police, made allegations against the police, the NPA, the judiciary itself, and correctional services, it appears a bit absurd, to be frank, because he has made clear allegations that these criminal syndicates are working with the judiciary. He hasn't told us which members of the judiciary. If you appoint a member of the judiciary to head the commission of inquiry, number one, who may be part of these criminal syndicates, then what do you imply? What are you implying? He has the powers to appoint a commission, but the judiciary, Commissioner Mkhwanazi, put it squarely as part of these criminal syndicates. Number two, it also seems a little bit odd because I don't really know how this commission will process the 120 dockets. Mkhana has made it very clear that the political killings task team, 120 dockets were taken from it. Some of it were ready for prosecution. What has happened to those dockets? Those that are ready for prosecution, what is happening to them? It seems to be more broadly, politically, just delaying tactics, really.
So, I mean, the presidency has responded, I believe, to your application with a letter on the 17th of July and referring to your complaints as premature, ill-informed and misplaced, saying that the terms of reference for the commission are not yet gazetted and the presidential acting appointing of Prof. Cachalia is also not yet finalized. Do you believe that this is a premature move?
No, he has made the announcement. The commission establishing it, he hasn't established the terms of reference. We are challenging who is heading the commission and how the commission is structured. He has announced that. He has announced the appointment of Cachalia as the acting minister. We are challenging that because it's unconstitutional. It's supposed to take effect on the 1st of August. He has announced it.
All right, Kevin, maybe let's bring you in this conversation. I mean, the MK Party is saying that, yes, with accordance to Section 91, subsection 3, the president does have the authority to appoint someone outside of the National Assembly, but in the role of minister and not necessarily acting.
Yes, correct. They are 100% correct in that assertion. It is perfectly stated within the Constitution that when any designate is going to be appointed outside of cabinet, that appointment is going to be in the form of a minister or of a deputy. So that's what the appointment will be. The Constitution doesn't necessarily have any express term that says that anyone can be appointed as an acting minister. And like it's been rightfully pointed out, where a minister has to perform an acting role, they will usually come from within the cabinet already. So this might be an issue of which sequence happens first. Does the appointment take place? Will they be appointed? In some sections, it has been actually suggested that Professor Cachalia would be appointed as a minister without portfolio, and then the duties and obligations of Minister Mchunu would then be transferred over to him. But again, that's giving the president the benefit of the doubt, because that's not what the president had announced. So that is just in some sectors of political debate and legal debate as to how it can actually be done. But again, we have to take this matter as it's been presented to us. And the way it's been presented is that he would be appointed as an acting minister. And the Constitution would not necessarily allow for that.
And the MK Party is saying that the leave of absence, rather than dismissing Minister Mchunu outright, do they have a point in a case in that?
Now, we've had a look at the MK Party's papers. From a reading of their papers, their argument is along the lines of there wouldn't be a specific provision allowing the president to place the minister on special leave. So to the extent that that is going to be the argument, yes, the Constitution doesn't specifically state that the president can in fact do this. However, there is what is called implied executive authority. So there is a discretion that is allowed for the president and other members within the executive to obviously exercise their functions and have authority over the running of cabinet. And it would be implied that this move might be done again under that authority. But again, as it has been stated, the president didn't announce it that way. There would be us again finding ways to actually make sense of what is happening. If we look at it as how it was announced and what is being challenged, there is merit in what the MK Party is actually saying.
So MK Party taking this to the Court certainly does have a case, in your opinion?
Again, the Constitutional Court has to be approached in this instance because it's an interpretation of the Constitution and it is of the functions of the executive itself. So those are squarely constitutional issues. And because of the timelines that they have to work with, this is an inherently urgent matter. The reason why the MK Party also, again, I'm not speaking from a position of knowledge as to why they had done this. I'm just making an assessment of the situation. But the reason why they have to approach the Court on urgency is an inherently tough threshold to overcome. So if you do tarry and take long in bringing matters to the court, your court might be the matter might be thrown out of court on the basis of urgency before they even look at the merits. And because these appointments are to take effect on the 1st of August, this is an inherently urgent issue. So to the extent that they had to make a decision, that is squarely within their rights. The court might have discretion to say that there are certain portions of their claim that can be dealt with in due course and others that have to be dealt with as a matter of urgency.
So Dr. Mthanti, you've given the presidency until the 21st of July to express whether or not they're opposing this application. What can we expect thereafter?
We expect that they will file. The matter is meant to be heard on the 29th, and obviously they could try to play some delaying tactics. The problem that the country finds itself is actually a very serious one. Crime is a serious issue in the country. And a police commissioner in a province with a lot of investigative power has come out and said there's criminality in cabinet. He has come out and said there's criminality. There's criminality in the NPA. There's criminality in the judiciary. This is not some ordinary politician or ordinary citizen. This is an individual who was heading that political killings task team or whatever. He was heading it. They've got a lot of investigative authority. South Africa is in a crisis. And I think just to go back a little bit on the background of it, I think we had the CR17 case where there was alleged criminality on the part of the president. Those documents were sealed by the courts. You had the Phala case where former Chief Justice Ngobo, said there was prima facie evidence of criminality potentially on behalf of the president. And again, nothing was done. The person at the center of this, Senzo Mchunu, was central to CR17. He was one of the chief campaigners, in particular in KZN. On that slate, he was meant to be the Secretary General of the CR17 campaign. So they were campaigning together, one to be president, one to be Secretary General. The same individual who is at the center of seemingly these criminal gangs, right? Same person is the one who declared the Phala investigation report top secret, right? So what you are seeing now is the potential criminality of the president is influencing his potentially could be influencing his executive behavior and allowing criminality to seep into the state. That's why our efforts on this are multi-pronged. One, it's the Constitutional Court. Two, it's mobilizing society. I think we've seen our marches in Durban and in Gauteng.
Right.
Right? Three is the motion of no confidence on the president. You can't have seemingly an individual who's potentially a criminal rooting out criminality within the state.
Doctor, I have run out of time. I just want to, with that trail of thought, maybe from you, Kevin, I mean, Dr. Nthati is putting out a political argument in how the president is allegedly protecting himself. Do you think he could have acted differently in 10 seconds?
Definitely. I think if we look at Deputy Minister Whitfield, it was decisive action, and that Deputy Minister was removed immediately without, quote-unquote, due process being taken. Again, if you also look at what the judiciary's comment on this was, the judiciary had said that if there are members within the judiciary that have been pinpointed, that General Mkhwanazi needs to bring that forward so that the judiciary can take action, so that the JSC, for instance, can take action against judges or magistrates or members of the judiciary that have been implicated. And that would have given us some form of finality as to that part, and we wouldn't have the comment that because there's a captured judiciary, members of the judiciary can't now head the Commission of Inquiry.
All right, gentlemen, we have run out of time, but thank you so much for giving us your perspectives on this issue. It's certainly one that is of national importance to the country, and we certainly do hope that we'll come to a decision that will be in the best interest of South Africans. So thank you so much, Kevin. Dr. Mthanti, thank you so much for joining us this evening.
Thank you.